Good morning, sir. This is Michael de Guzman. Move your chair. That's fine.
All right, Mr. Guzman, can you hear me?
Yes, sir.
Okay, you're coming through, but not very loudly.
Oh, yeah. Give me one sec here. Let me adjust, or I'll speak louder as well. Is that better, sir?
Okay, I take it you are David Anthony Parent?
Yes, sir.
Okay, Mr. Parent, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
Yes, sir.
Okay, I'm going to kind of short circuit what we normally do in court and do a little bit of your attorney's work because we're doing this via Zoom. So I'm going to hold up what purports to be the last will and testament of Robert Anthony Parent. Do you recognize that as being his will?
Yes, sir.
And I'm going to go back to the signature page and ask you if you recognize that as being his signature on that document.
Yes, sir, it is.
And after the date he made this will, which purports to have been on August 8th of 2022, did he ever change it or revoke it?
Not that I know of, sir.
Okay. Go right ahead, Mr. Guzman. I believe you've got the proof of death and other facts.
Yes, sir, I do.
Okay, if you'll go ahead and go over that.
Yes, sir. Please state your name and residence. My name is David Anthony Parent. I live at 225 Lone Star in Bernie, Texas, 78006. And was the decedent your father? Yes. Did he die on July 28th, 2023? Yes, he did. And did he die in Jefferson County? Yes, he did. Was his principal home and residence in Jefferson County? Yes, it is. Who is named executor in the will? Originally, my mother was. However, she predeceased him by 9 months, and I was the successor executor after she passed away. As an executor, you're disqualified if you're any of these. If you're an incapacitated person, a convicted felon, a non-resident of the state, a corporation not authorized to serve as fiduciary, or a person whom the court finds unsuitable. Are you any of these? No, I am not. I am qualified. Are you seeking for letters testamentaries to be issued? Yes, I am. To the best of your knowledge, as the judge had asked, the last will was signed on August 8th, 2022. That is correct. To the best of your knowledge, did he revoke this will or execute a subsequent one? I do not believe he revoked that will. Were there any children born or adopted after the will was signed in August of 2022? No, there were not. Was he divorced after August of 2022? He was not. Did he name a state, a government agency, or a charitable organization as a beneficiary? No, he did not. And lastly, information on the application to probate, is all of that correct? To the best of my knowledge, it is all correct. That is all I have, Your Honor.
All right, so what you're going to do is you're going to sign that proof of death and other facts in your oath exactly as your name is typed on it before a notary public in Mr. Guzman's office. He will then e-file those with the county clerk's office here. Once he does that, I'll sign an order admitting your father's will to probate and authorizing the county clerk to issue letters testamentary. Those letters testamentary will give you authority to act on behalf of your father's estate, to marshal the assets, to sell real estate, to deal with financial institutions or stock transfer agents, or whatever the case may be. Those letters are good for 90 days. If they go stale, you can get more from the Jefferson County Clerk's office. Make sure that you cooperate with your attorney in doing an inventory. The estates code requires one to be filed within 90 days of the date I signed the order. We're also going to email this instruction sheet that outlines what your duties and responsibilities are to your attorney. Please take some time to review those. And other than that, Mr. Guzman, if you'll just get me those executed proof and oath, and we'll get the order signed, okay?
Will do, sir. We'll have them signed today. Thank you, Judge Brandon, for your help today.
All right, y'all have a great week.
Thank you. You too. Thank you. Good day.
Bye-bye. Okay, let's see here.
Page,
There you go.
Page Jones. On Ellender.
Mm-hmm.
About the judge?
Yes. And our audio is on. But I can't hear him anymore yet. No. He's reviewing the will.
All right, Ms. Jones and Ms. Ellender.
Yes.
Okay, is it Ms. Ellender or is it Ms. Garrett?
Oh, it's Mrs. Garrett. Ellender's my maiden name.
Okay. All right, if you'll raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God?
Yes, yes.
Okay, I'm gonna hold up what purports to be the last will and testament of Elmer Ellender. Do you recognize that as being his will?
Yes, I do.
I'm gonna go back to the signature page. Ask you, is that your father's signature on that document?
That is his signature.
Your knowledge, after the date he made this will, which purports to have been on January 29th of 1979, did he ever revoke it?
No, he did not.
Okay, it looks like he tried to do a little bit of interlineation.
Yes. They talked about for years changing it and they never took care of it.
And those are not going to be effective.
No, that's fine. My mother's going to use every dime she has to live, so.
Okay, go right ahead and you can go over the proof, Ms. Jones.
Thank you, Your Honor. Please state your name for the court.
Deborah Lee Garrett.
And your maiden name is Deborah Lee Ellender, is that correct?
That is correct.
And what city and state do you reside?
I live in Montgomery, Texas.
And you're the daughter of Elmer Ellender, is that correct?
The oldest daughter, yes.
He passed away on September 1st of 2024, and that's been less than 4 years, is that
Yes.
correct? And he was a resident of Jefferson County at the time he passed away?
Yes.
And the judge has held up your father's last will and testament dated January 29th of 1979, is that correct?
Yes.
And judge already asked you, he never revoked the will, correct?
No, he did not.
And there were no children born to him after the date of the will, is that correct?
No.
I'm sorry, I asked that the wrong way,
oh,
but there were no children after the date of the will. Is that correct? Yes.
Oh, no born? Oh, yes.
Right. Yeah,
No,
okay. And there were no marriages dissolved after the making of the will. And does the will name a state governmental entity or a charity as a beneficiary?
No.
And the will appoint your mother, Mary Helen Ellender, to serve as independent executrix, but she has declined to serve in favor of you as the successor executrix. Is that correct?
That is correct, yes.
And the will appoints you to serve as executrix without bond. Is that correct?
Yeah.
Is there any reason you would be disqualified to serve as independent executrix?
No.
And is it true that a necessity exists for the administration of this estate?
Yes.
And this is also a non-taxable estate, and we are asking the court to waive appraisers. Is that correct?
Yes.
That's all we have, Your Honor.
Yeah, there was nothing, no original in the file, nothing was still envelope, that's, we just filed that.
All right. So what you're going to do is you're going to sign your proof of death and other facts and your oath before a notary public in Miss Jones' office. She's going to e-file that with the county clerk's office here. Once she does that, I'll sign the order admitting your father's will to probate and authorizing the county clerk to issue letters testamentary that'll give you authority to act on behalf of the estate. We're also going to email Miss Jones a instruction sheet that I give to everybody to explain what your duties and responsibilities are. So take some time to go over that and review it. Make sure you cooperate with Ms. Jones in doing an inventory or affidavit to be filed within 90 days of the date I sign the order. But other than that, I know she'll guide you through the process, so I hope everything goes smoothly.
Thank you,
Thank you,
sir.
Your Honor, for allowing
Y'all
us
have
to
a great
hear
week.
remotely. You
Thank
too.
you.
Okay, Mr. Bryan. You know.
Okay. Nope. All right. Okay.
Is there Edward Wolf on it?
Huh?
Is Mr. Wolf on it? In the waiting room? No, I know that's the applicant. There should have been a subscribing witness. I mean, a handwriting witness. Okay.
No, we're not muted
I mean,
anymore.
I mean.
Okay, Mr. Bryan, can you hear me?
Yes, Your Honor.
All right, Ms. Wolf, if I could get you to raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give in this call shall be the truth, so help you God?
Yes, I do.
Okay, Ms. Wolf, I'm going to hold up what purports to be the last will and testament of Eva Marie Hodges. Do you recognize that as being such?
Yes.
And I'm going to go to the signature page and ask you, do you recognize that as being your mother's signature?
Yes.
After the date she made this will, which purports to have been on February 28th of 1985, did she ever change it or revoke it?
No.
Okay, and it looks like your mother passed away back in 2004, but we're
Yes.
20 years later trying to admit the will to probate as a muniment. So, Mr. Bryan, you want to explain this to me?
Yes, Your Honor, and this is a case that I've actually inherited, but you are correct. We are seeking to have the will admitted as a muniment of title to recover basically an investment account that actually is apparently has dwindled some, and then some unclaimed property with the Texas Comptroller's Office. Miss Wolf is the sole surviving heir of Eva Marie Hodges. In other words, she was the only child of Eva. So there's certainly not any contest, even if this court, if we were to have to go back and do an heirship determination, which would be very, very hard, it still ends up everything to Miss Wolf.
All right. All right. If you will go over the proof of death and other facts with her, please.
Yes, Your Honor. Miss Wolf, could you go ahead and state your name?
Mary Lynn Hodges
Oh.
Wolf.
And Marilyn, are you the surviving daughter of Eva Marie Hodges?
Yes,
She passed away on or about December 2nd, 2004 in Port Arthur, Jefferson County, Texas at the age of 83. Is that correct?
yes,
Now, we are well outside of 4 years after your mom's death. Is that right?
yes,
And the jurisdiction and venue is proper there in Jefferson County because that's where your mom lived. In other words, that's where she was domiciled. Is that correct?
yes,
We've issued citation and that's been returned as in the manner required by law. Is that correct?
yes,
Yes.
Now, your mom had a valid last will and testament dated February 28, 1985, and that was never revoked as far as you know. Is that correct?
yes,
And that's the same document that the judge just showed you there on the screen.
yes,
Your mom was over 18 over the age of 18 at the time she executed her will. Is that correct?
yes,
Your mom does not have any unpaid debts, and of course, we are long past the statute of limitations on any debt collection for your mom's estate. Is that correct?
yes,
So the only thing we're trying to do is just transfer title on, as we mentioned, some of the bank account and also the
Do that.
recover some unclaimed property. Is that correct?
yes,
Your mom did not have or adopt any children after she made her will. Is that correct?
yes,
She was not married when she passed away. Is that correct?
yes,
You
Okay,
said-
it's sufficient. Have you read the proof of death and other facts?
Yes, sir. We have those right here in front of us.
Okay. Is everything contained in that proof of death and other facts true and correct and within your personal knowledge?
yes,
Okay, so, Mr. Bryan, the only problem I see is it requires two disinterested witnesses. You've got one witness as the husband of the applicant, which I don't consider disinterested. And then you've got another one that is just a copy of a document that was not filed, sealed, or anything else. I can certainly take Ms. Garcia's testimony over a Zoom or something like that. Do you have someone else besides Ms. Wolf's husband that could be a disinterested witness?
Hey, Judge, I do have here in my office Linda Melson, who is generally familiar with she is generally familiar with Ms. Hodges' signature based on her review of various documents that she's seen. And of course she's completely disinterested in this. She's not related to anybody.
Okay, ask her to get in front of the camera.
Linda, can we?
Okay, and your name is what, ma'am?
My name is Linda Jean Melson, M as in Mary, Elson.
Okay, would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in this call shall be the truth, so help you God?
Yes.
Okay, how are you acquainted with Eva Marie Hodges?
I actually am acquainted with the applicant who at a church function explained to me the difficulty that she has had in accessing her mother's assets, being a Putnam investment account and being some mineral interest. And that's how I met her.
Okay, go right ahead, Mr. Bryan.
All right. Now, Linda, you are you've seen the will dated February 28th, 1985. You've seen a copy of that,
Yes, I have.
and that's the same document that we're trying to get admitted to probate today. Is
That's
that right?
correct.
Okay. And you have also in your course of dealings with Ms. Wolf, you've reviewed several documents that have been either filed with public record or were found within the papers of Miss Hodges. Is that correct?
That's correct.
So you've seen her signature on a number of documents, including some documents that were filed in the public records. Is that right?
That's correct.
And the signature that is on the will dated February 28th, 1985, that is in fact the signature of Eva Marie Hodges. Is that correct?
That's correct.
And you do not have any interest in this estate?
I do not have any interest in this.
Okay, and if you will get her to sign a proof of decedent's handwriting, and then if you can get with Miss Garcia and schedule her to come in here for just to testify, and we'll get her to do, because I don't think the written questions aren't sufficient because they didn't come in accordance with the rules of the court.
Yeah, Judge, she had emailed that document to me, and so rather than open that document, I then sent it by mail, straight to your clerk.
Okay, it wasn't in a jacket, and it's a copy, and
yeah, she just
we
didn't
don't
get
have
it
anything,
right.
but we'll be happy to get her on Zoom, or she can come up here to the courtroom. Since it appears she lives in Jefferson County, she lives in Groves, but she wouldn't be too far from us. Either way, we'll either do it by Zoom, or she can come up here and we can get you back on Zoom, and we'll ask her a couple of questions and get that done. Okay?
Yes, Your Honor, we'll do it.
All right. Y'all have a great week, and we'll wrap this up as soon as you can talk to her. Okay?
Very good. Thank you, Judge.
All right. Y'all take care.
And emails. Back and forth to him about that. I kept telling him. Another witness, we need another witness. He said, I don't think so.
Yes, sir.
Yes, sir.
Good morning, Your Honor. I think you're on mute, Your Honor.
Okay, Mr. Munson, we're here on a status conference in the estate of Anthony Herbert Connor Sr. We apparently have a number of years of, like 7 years of past due annual accountings on this. Of course, I can't imagine why an estate would be open that long, but in any event, can you give me an explanation of what's going on?
Yes, Your Honor, I'd be happy to do so. First off, thank you for letting me appear by Zoom. It was very helpful. The next part is that we were filing those annual accountings. Like you said, it was probably about 8 years ago we filed the last one that we had filed. And most of the time, I was working with Anthony Connor, who is the administrator's wife. And during that time, I didn't know this, but she had developed dementia. And so when speaking with Anthony after I received a notice from Your Honor's court, I got with him and I said, hey, we need to request all of these statements from the bank. And so within the last 7 years, the bank, it took them about 10 days to pull those. But the ones that are longer than 7 years, they told my client that they would not be able to provide. And so he let me know that about 2 weeks ago. And so I told him that he really needs to search his house to see if he can find those bank statements that because there's a gap in time. And so in speaking with him, I told him, but hey, let's just go ahead and we're going to do our best to fill in those gaps because as you can see from that previous accounting, there's just real properties, a couple of broken down cars. I think there was a little bit of rent being collected each year, but then property taxes paid, homeowners insurance, and things like that. So there wasn't a lot going on. I will tell you, Your Honor, that in 2022, the property was foreclosed on for tax purposes, and the vehicles were on the property and things like that, and that'll be reflected in his annual accounting. So I did let Mr. Connor know that let's do our best to fill in these annual accountings, get them before the court because there really is no reason for this administration to be open at this time.
Yeah,
So,
let's try to get something filed and get an order closing this estate. If
yeah.
assume everything's been distributed in accordance with, I don't remember if there was a will or if this was intestate distribution with the determination of heirship, but
Yeah, and I don't know that there is, based on the estate was kind of becoming upside down quickly, and then once it was lost to taxes, I'm not sure that there's anything to distribute. That definitely will have to give notice, but we won't be able to do that. But Your Honor, we will get those on file, and so we're just asking for a little bit more time.
okay. I'm going to reset this for the end of February. What date? February. For another status conference, if you can get them all filed and we can get everything cleared up by then, you won't have to reappear.
24th. Yeah, I'm not sure. We'll have to get back to this.
February, it's March, I got school.
I think the 26th is your bank board.
For some reason, it doesn't seem we're doing the last week of February. Okay, it's Val. Can you give me the link? Thanks.
'26th, but I can do the 24th.
24th.
But we're going to schedule you for February 24th. If we can get everything taken care of before then, you do not have to appear, but otherwise, let's plan on that. February 24th at 10 a.m.
Thank you, Your Honor.
And if there's a problem, give us a call. And give us a status conference a week before if there's a need for it. Just give us an update to the status. You can call Melissa in my office.
Thank you, Your Honor.
All right, thank you. You take
That
care.
takes you. All right, thank you. Bye-bye.
I think Josh.
Mr. Hines? Do you have somebody on Zoom?
He's coming. He's coming in now.
Okay, and Travis Neal Osborne, is he here? Come forward, please, sir. Okay, come over here before we get Mr. Rogers on. Tell me, this turnover order?
Yes, sir. So the decedent, Mr. Osborne, resided together at the time of her death. He has possession of some personal property items that belong to the estate. We had sent a demand letter back in August. There's a few things at issue here. One is there's miscellaneous personal items, which he says he has. You know, talking back there, I don't think that's going to be an issue. She owned a car that remained in his possession. We sent that letter asking to recover that. We never got it. The car was ultimately repoed while in his possession, and so there's a bunch of repossession fees and everything on top of that. Also, after her death, she received a payroll direct deposit into an account that they held jointly. We asked for those funds. Again, we sent the letter back in August. We never got a response to it, so we filed the show cause motion.
Okay.
Your Honor, 2 days after the funeral, they showed up at the house. I opened up the doors. I said, "Come in. Take what you want." They had a U-Haul trailer and they filled it up. I'm not trying to keep anything. I mean, they're asking for miscellaneous things like puzzles and things like that. I really don't want. I don't want any of these possessions. There is a couple. They have listed on there a couple of hog head mounts that the deceased and myself had went and got together in Texas. There in Wisconsin. That was the only contested thing in the house. I said, "Come on down. That doesn't have any sentimental value for you." That was her and I. I've been trying to be very civil.
You live where?
Winnie.
In Winnie?
Yes, sir.
It's actually Jefferson County.
Huh?
It's Winnie
Yeah.
mailbox, but it's Jefferson County property.
Yes, sir. I live outside of Winnie,
Okay.
Jefferson County. I can show you messages on my phone where I texted Don Rogers saying, "Hey, I know you were looking for this. We couldn't find it when you were here. Here it is. Here's pictures. I have them here." I'm not trying to take anything or keep anything from them. When they sent the offer letter, I had told him, I have a storage unit also that does have some of her things in it. And they haven't opened it in over a year. But I told him I could put her clothes and whatever belongs more in the storage unit, come get it. I didn't hear back.
Where is your client?
He's on Zoom.
I mean, where do
He's
you
in
live?
Wisconsin.
Wisconsin.
And also speaking to him earlier
I can't get it on.
in the letter, asking for the same stuff. I just thought it was odd. I was supposed to take a bunch of totes for personal belongings and drop them off at some office. Doesn't seem legitimate, but I want to be here and I want to settle this civilly. And the papers for this, I work in refineries. I'm rarely home. There's a hang tag on my door. I reached out to them. What is it?
Do you have a proposed order?
I do not have a proposed order, Judge. I want to
Okay,
come back
get a
and talk to you.
proposed order and get it to Mr. Osborne. Let him review it.
I got it via text.
Okay.
And I didn't get him time to print them out until this weekend. I couldn't get.
Well, I'm talking to him about an order of
Oh, I'm
the court. So I'm asking him to prepare an order, to get that order to you for me to enter, which is a turnover order. If you have any disagreement with it, I will let y'all call back in here and have a phone call status conference with me to see where the disagreement lies.
How do you want us to handle the repossession?
I guess that's a good question. Why did you allow the vehicle to be repossessed without turning it over to Mr. Rogers?
I did tell Mr. Rogers he couldn't have it. We even discussed how much, he said, how much is on it? This is strange timing. The lease ended right about the time she passed away. I said, I'm not sure, I think about 30. He said, yeah. The vehicle wasn't locked up and hidden. The keys were in it, sitting outside for months. He could have taken it that day. I don't want it. I didn't drive it.
Well, Judge, we sent the demand letter. We asked him to contact us. We would have gone and got the
Yeah,
vehicle.
why didn't you contact them after
I
you got?
told you that I told Mr. Rogers I would put everything in a storage unit. He could come get it. You have to
You can't
understand.
get him on.
No,
You
it
have to
says, it
understand that.
says he will start video later, so he won't start the video.
Okay, yeah, just,
Her and the deceased and myself were engaged to be married in September 17th of 24. This wasn't just a person. I would feel awkward taking anything of hers here and putting it in an office. Why not come get it?
Where did, okay, do you want to talk to your client about the vehicle?
sure.
Apparently there's some dispute. Apparently he says he's willing for him to take it.
This one around, but it's still.
Mr. Rogers, can you hear me?
I can.
Okay, so he's good now? So we're here, and Mr. Osborne is here. There's a question about, or just so you know, we talked to the judge a little bit as to the personal items on our list. He says he has possession of those and we can turn those over. He had mentioned that he had communicated, after I'd sent the August letter to him demanding he turn those over, that he had reached out and spoken with you either via text or phone call. Is that correct?
That is incorrect.
Okay, so you never heard from him after we sent that demand letter asking for possession of those items?
Correct.
He also said that he had told you that you could come pick up the vehicle whenever you wanted. Is that correct?
No, that's incorrect. While we were down there, he said we could not take her computer, we could not take her vehicle, her car, and we could not take her camper. And the camper and the vehicle were both repossessed. And that's how I found out that it was not in his name as he claimed.
Okay, so and I've got the records on the car. I believe it's about repossession fee on the car is about $1,800. Is there a repossession fee or charges on the camper?
There is.
Do you know how much those are?
Not right offhand, I don't. I believe it's about $1,200.
Okay. And then what about after we sent the demand letter, did he ever reach out to you about the vehicles or the camper?
No.
Okay.
I have no contact with him at all about those items.
And we haven't gotten, and I assume also about the direct deposit payroll check, no communications about that, and you never received that money either, did you?
So many documents.
No, I did not. While I was down there, he claimed that it was deposited, but never offered to give her check back.
Okay.
One other thing I'd like to clear up is before I ever went down there to collect my daughter's items, I asked him if it would be okay, and he invited us down there.
Okay.
It wasn't just show up and rip his house apart.
Okay. And y'all went and got a lot of items, but these are the items that are still left, correct?
These are the items that he would not let us take.
Okay. Okay, Your Honor. That's all I have.
Okay, so we have a very different stories here.
Yes, sir.
Do you have any text messages or anything to prove
I
you're
have text messages.
after August?
I have some from after he was there of items he was looking for in the house. Couldn't find a bunch of fishy stuff he wanted. And he's saying, hey, I found this. I'm sorry. Trying to work with him.
And Judge, it's
And
based on those pictures that we came up with the list of items that's included in the letter.
Because we had talked, I told you, we had talked about this when he was there, and I had a list at the house. If I run into this, or if I happen to go to my storage unit, I will be looking for these things. As I ran across them, take a picture, let me know.
Okay, so we have a big difference of opinion. If you have no communications or text messages or voicemails after August of 2024. You did not respond to his request for information after he sent you the letter in August.
Paper, no, sir.
Did you call him and talk to him?
I did not.
One of those situations where people think if they ignore things, they're going to go away, and they don't go
I'm
away.
not trying to ignore it. And I had to print these out in order to know to be here today. I could read them on my phone. I'm not trying to ignore any of this. And there's items on here on the list, such as a bracelet. I don't know. Or puzzles or games for the kids. I don't want any of that.
Okay, I need for y'all to get together and talk, find out where you agree and what y'all disagree about. And then get that list to me with the proposed order of what y'all disagree about.
We'll talk to it before we leave.
Okay, is there anything else you want me to know?
No. I want this to take care of it. I'm not trying to do that.
I would like to say one thing if I could.
You may.
I have emails from him where I didn't get any thing from him saying that I could pick these items up, including her income tax statements. I wanted those and he never returned them. And I finally got frustrated and I said, I'm going to hire an attorney. And he said, sounds good. And that's the last email I ever got from him. And I can produce that email.
I'll do it right now.
Okay. Well, you can produce those to your attorney. You can include them with the order, anything you want to include in response, you can put with it, okay? So print those out and put those with it. And I'm going to review those documents and I may call y'all back.
Okay.
Okay.
All right. Thank you, Judge. Thank you.
All right. Thank you. You may be excused, Mr. Rogers.